everyone. I'm Leslie Stein, Director of the Government Law Center here at Albany Law School, and we are very, very excited to have to be hosting our first Fair Trial Free Press conference here at the law school, although it has been in existence for a very long time. I'm going to make a few very brief remarks and some instructions to everyone, after which we'll turn it right over to our moderators and our panelists. But first, I just want to introduce to you our fabulous Dean, Alicia Willett, and she needs no introduction. So I'm going to let her say the first few words.
Hi, everybody, and welcome. And I think I do need introductions to some of you because you are new to the law school. So welcome to all of you. Thank you so much for being here. It's a real honor to be hosting this Fair Trial Free Press conference. When I heard about it, I thought, well, that should be at the law school, right? We know as lawyers and future lawyers that that law is critical to democracy and justice. And we also know that the press and the free press is critical to law, to a functioning democracy and to justice. So bringing them together here at Albany Law School is just, it's exciting. I can't wait to see what this conversation entails. I think we'll all learn. I am going to warn you, we've invited students. They'll be coming in and going. People have classes. So please forgive the interruptions. I want them to be here to learn as much as they can. Welcome to everyone who's here in person. Welcome to everyone who is with us on Zoom. Thank you to all of our esteemed panelists for being here. And ready, set, go. Let's bring it on. Thank you.
Thank you, Dean. Okay, so I do want to welcome you all and also to the people on Zoom. And today's discussion will be moderated by the Honorable Albert Rosenblatt, retired judge of the Court of Appeals, and Rex Smith, former editor of the Albany Times-Union. We have a very distinguished panel of judges, attorneys, and journalists. And I'm just going to name them and tell you what they do now. But if you want to know more about them, and you should read their bios in the course materials. First, we have Susan Arbetter, political anchor, Capital Tonight, Spectrum News, and Susan last minute was not able to be with us in person, but she is there up on your screen. So she will be participating with us. Unfortunately, Professor Stephen Clark was unable to be here today as well. We also have with us Mary Pat Donnelly, class of 1997. She is currently the Rensselaer County District Attorney. We have the Honorable Michael Garcia, a current associate judge on the New York Court of Appeals. Michael Greigel, a shareholder in the law firm of Greenberg Traurig LLP. E. Stewart Jones Jr., class of 1966, a partner with Jones Hacker Murphy LLP. The Honorable William Little, class of 2005, who is currently an Albany County Court judge. Judith Patrick, the Vice President for Editorial Development, the New York Press Association, and Casey Seiler, who is the editor of the Times-Union. There's just a few housekeeping items. We are hoping to have time for questions and answers following the panel discussion. Those on Zoom should submit their questions in the chat room, and they'll be fielded by Patrick Woods, the Deputy Director of the Government Law Center. And those who are here in the room should submit an index card. You all should have received one with your questions. And if you haven't, we have Ariel right in the front of the room, and she'll give you one. And you can return them to either Ariel Chell, who's in the corner, or myself, and we'll submit them to Patrick so your questions can be asked. Please don't forget that to promptly submit your forms for CLE credit. And for those of you who are on Zoom, you will need to listen for the code words that will be announced throughout the program, and make sure to include them in your form. And that's the last you're going to hear from me, except for thank you at the end. And we do have a reception after the program with lots of goodies. So I hope you'll join us for that too, even if you have to leave for class and come back. So with that, I'm going to leave it to Judge Rosenblatt and Mr. Smith. Thank you.
Thank you. Just by way of explanation, the New York Fair Trial Free Press Conference was formed under the Court of Appeals when Stanley Fuld was the chief judge in the early 70s. It has existed for many years under different leadership by our bylaws chartered by the State Education Department. The chief judge of the Court of Appeals is our president, and the vice president is always a journalist, a role that I've had for about 20 years now, succeeding the editor of Newsday, Tony Merrow. And we are really very pleased to be here at Albany Law doing this program. We've moved around the state a number of times. We've done it in TV studios at the NYU Law School, at Syracuse University, Newhouse School of Communications. We just think that this is a great opportunity for us to interact with this great law school and to be a part of your curriculum and a part of the life of some of the lawyers who continue their education through the CLE here. So the key thing that I want to say to our panelists is there are no wrong answers. You know, this is all fun. Nobody's career is going to hinge upon what you say here. We promise, sort of. We do the best we can anyway. And we just want to have some illuminating conversation about some of the issues where the law and the media interact at a crucial time especially in the life of the media, where there's so much change going on and where a lot of the standards that we have assumed for many years are open to question. So Judge Rosenblatt and I have done this together for many years. Come on up, Alan, you can take over here.
Yeah. I thought I'd just briefly explain what this title, what this convocation is all about, and what we mean by a gathering of fair trial free press people. If you were to ask yourselves, what is it about the press that is most important in our American constellation? It is the word free. Without a free press, we would be like a totalitarian nation. And we're immensely proud of the freedom of the press as prescribed by the First Amendment and its history and its adjudication. What is it about a trial that we most value? Fairness. So it's no coincidence that we call this fair trial, free press. Those two constellations, however, exist independently and they function well independently, but occasionally the institutional differences bring them into some sort of collision. And I sort of became aware of this when I was a county judge before being on the Court of Appeals. And when I was district attorney in Dutchess County, there was hardly a day that went by that we didn't have some interaction with the press, and came to realize that my job in the court system was very different and had different institutional constraints than the press. So given that Judge Fuld and later Judge Kaye had fashioned fair trial free press to bring it into its full flower, I'm ready to say that we really do not expect answers here, and we're not going to solve any problems. What we hope for is a recognition by the media people and by the people in the bench and bar to appreciate each other's institutional concerns. And when we appreciate that we are in different universes and that our institutional concerns cannot satisfy one another fully. If judges play into the media, that's not a good thing. And if the media want judges to look good or to cater to them, that's not good either. The press must be free and the judiciary must be independent. So by talking to one another at a convocation like this, we can understand and appreciate each other's institutional constraints and put ourselves in each other's shoes, not to come out with perfect solutions, but just to understand one another better so that things go down as well as they can. So with that, we're going to start it off.
Okay, let's talk about this hypothetical. you probably have read the hypothetical in the material that's been sent out, but just broadly to describe it, we have an interesting outbreak of something that seems to be influenza that is resistant to the vaccine. Some surprising number of them fatal. This is found in an upstate rural county. This gets to the media in the form of a little dinner that is that a state government, flack is the term that we use. Somebody working for the state health commissioner intends, hopes might be something romantic with a reporter for a local newspaper or a group of local newspapers, and goes on telling this to the reporter, who feigns, well, is interested, but secretly writes the notes. If you've ever seen All the President's Men, the movie, or if you've read the book, you know that Carl Bernstein actually ran away from a dinner a couple of times and took notes on the only paper he could find, which was toilet paper, which became the notes for his story, so that he wouldn't be seen to be taking notes. So I have a couple of questions. By the way, this hypothetical will kind of move from one group of people to another. There are a lot of questions for journalists at the beginning, for the bench later on as it goes on, which is kind of the way the flow of things tends to go. I might ask a couple of the journalists first to think about this, because there is I wonder about the ethical comfort level in the range of reporter-source relationships. You know, here we have a reporter seeming to take advantage of a government official's romantic interest, and you wonder about that. This is Casey Seiler, editor of the Times-Union. This is problematic, isn't it?
Yes, very much so.
Does it ever happen? You want to move that microphone over so that the folks online can hear you. There we go.
Yeah, it would be extremely problematic. And I guess my sort of first question is Robin Digger a woman? I think the gender is sort of left indistinct, probably carefully so by, oh, there we go, sorry. Carefully so by whoever designed this hypothetical, Rex.
Does it matter?
Yeah, no, it doesn't. It definitely doesn't matter. I know it does happen that there are reporters who might work with what they've got, regardless of gender, to forge relationships, friendly, hopefully mutually beneficial in the sense of exchange of information with blacks, as you so accurately put it. But no, that is a relationship that or that is a tactic that I would not want a reporter of either gender to employ. I do not like it when it turns up, as it so often does, in Hollywood's depiction of journalists from absence of malice on back. The only source-reporter relationship in cinema that I approve of is Mel Gibson and Sigourney Weaver in The Year of Living Dangerously, only because it is Mel Gibson and Sigourney Weaver. That is, I believe, the legal term force majeure. But no, that is ethically not cricket, as we say.
But in real life, Susan Arbetter, here you are on television, and one of the great TV political reporters of our time is Chuck Todd of NBC's Meet the Press. His wife, you know, is a Democratic political consultant. So surely a little intended romance is not nearly as close a relationship as that. How are you going to guard against those kinds of ethical constraints when that's just the reality of things?
So journalists, Rex, don't have a bar exam that they need to take. We all sort of police each other, frankly. And an ethical journalist, and that's what I hope we're all here today representing, would make sure that any sort of relationship they have with the source is completely on the up and up, and that both the source and the journalist have communicated. I love over communicating. You know, you have to really say, I know that you like me, but I am not here at this dinner for a romantic reason. I am here because you are the spokesman for DOH. Mr. Leaks. So as much as I know you like me, that is not why we're doing this. I mean, you have to be really, really open and frank when it comes to your sources, because that's the way those are the ground rules. You have to set them with your sources.
Yeah, so you're the next guy to talk to, Mike, about this. Mike Greigel, who has represented many journalists, what are the legal issues that arise in journalists' relationship with sources?
In addition to a journalistic ethics question that's implicated in the hypo, there's also a legal, because if the reporter is speaking to the flag for DOH in an official capacity, it's recognized and acknowledged as such. Even an informal sit-down interview is going to qualify for protection under New York statutory report privilege, which is in Civil Rights Law, Section 74. And what that does is it lets the press report the information provided in this instance from the DOH flag with absolute impunity from defamation or any other tort claim, even if the information is false, as long as it's accurately reported. The question here, if this is sort of a social thing and the DOH flag isn't really, they're just having a dinner date, would the New York civil rights law expand its privilege that far? And I think that's probably questionable. So in addition to what I understand is the journalistic reluctance that Casey and Susan have expressed, there is an issue on the margins here that could be very important for a defense of the subsequent reporting.
So Judy Patrick, former editor of the Daily Gazette, you ever run into this problem? And is there ever a time when a reporter is off the clock so that the notion that Mike puts forward that what is said may not in fact be protected could be problematic?
So I'd like to defend the reporter a little bit here, because the reporter, this could very well be a business dinner. And as long as the reporter pays her fair share of the dinner, I don't have a problem with it. I mean, she doesn't consider this a romantic relationship. I agree, romantic relationships with sources are bad. I also don't have a problem with her going into the ladies' room or the men's room and scribbling down notes. That's fair. That doesn't matter at all. So someone in a position of authority, when they're talking to a reporter, they're always on the record unless they have an agreement that they're off the record. And in this case, there was no agreement before they walked into the restaurant that this is an off the record dinner. So she or he is free to cover whatever she wants.
Well, so she does, or he does. And we did, Casey, to your point, this was intentionally fuzzed up so that we wouldn't have any assumptions about gender roles here. But Digger, this reporter, they contacted several doctors confirming the outbreak. One of them sort of with humor refers to it as duck flu, believing that this animal-human transmission might have come about as a result of duck hunting season, which had just gotten underway. And the Blueford Bee, one of the newspapers that publishes this reporter's work, headlines the story as Duck Flu, the next COVID. And because that gets picked up by media around the country, it becomes a huge story on the Blueford Bee's digital site. The doctor, meanwhile, complains to Digger and to Digger's editor that he was misquoted in the article, that Digger had violated an understanding their conversation was off the record. You know, it just kind of makes you wonder, back to Mike Greigel, is there legal peril for a news organization if a reporter uses information that a source insists was provided off the record and on background? Is there such a thing as somebody saying, this is on background, you don't have a right to use it? And if you do, is there anything that can be done about that legally?
But it's a complicated question, because most responsible news organizations actually have editorial policies. Some of them that are written down in newsroom manuals that address promises of reporter source confidentiality, because they do raise serious legal implications for the publisher. So typically there is a rule, and I'll be interested to hear what Judy and Casey have to say about this, where a reporter can't make a promise to a source of confidentiality or off the record unless they first get up the chain editorial approval. Now that dynamic is inherently problematic, of course, because oftentimes a reporter's been working to get a source. They have cajoled them, built confidence, established trust and relationship, and the source is about to spill the goods. and says, but I have to be off the record, or you have to promise me confidentiality. And it doesn't quite work so well for the reporter to then say, well, give me 15 minutes, I have to consult with my editor, because you may lose it. But there is a case that some of you, the students here who have taken con law or First Amendment courses, called Cohen v. Cal's Media, which is a US Supreme Court case from 1991 or 2. And there was a source who gave information to a reporter for the Minneapolis Star Tribune who was covering the gubernatorial campaign. And it was about one of the candidates. The source was working for the other candidate, as I recall. The reporter promised confidentiality. When the information came in, they went to the editors and their determination was made editorial. It's such bombshell newsworthy information that we not only are going to publish what the source told us, but we're going to identify the source because it's relevant to our news coverage of this. That happened. The source ended up losing his job. He sued the Minneapolis paper for breach of the promise of confidentiality. And the court, the US Supreme Court said, neutral laws of general applicability that only incidentally burden First Amendment freedoms do not violate the First Amendment. So if you're going to promise a source confidentiality, generally that's okay. Bear in mind that usually it should be discussed with an editor, if at all possible. The one promise that can't be made is we will publish what you tell us. That is a promise that a reporter really should never make to a source.
Well, I'm kind of stunned by the Cohen v. Coles Media Company because it is interesting that initially that case was held to be enforceable, an enforceable contract. Appellate court in the state of Minnesota initially held that was an enforceable contract. And what do you think about that, Judge Garcia? If this were coming up to you, you know, this is contract law, which is kind of beyond what we journalists ever think we might have to worry about. But lawyers. And most I just talked to a law student who's going to get a job in contract law, and I wish he were still here. But what do you think about an implicit contract, or that actually sounds pretty explicit? I'm not going to use your name, and then they do. Is that a violation?
You know, I don't know, wouldn't comment on a case, obviously, but just as a concept, it seems to me, no. I've never seen anything like it. When I was thinking about this hypothetical beforehand, I looked around a little bit on that issue, and, you know, it seemed more an issue of journalistic integrity, you know, policy, than it would a legal contract issue. And again, I haven't done really any research on that. I've never had a case like it, but I don't know of a case like it. It's interesting, when I was doing, not in this job, but in the private sector, a high profile investigation, a journalist printed something that said, oh, he's so very careful, even when he's speaking off the record and on background. I thought it was kind of a violation of something, but
Yeah.
but that seems to me really a journalistic relationship, not a legal matter.
Well,
Let me say something as a lawyer to other lawyers.
just lean into that microphone next to you as you say things, folks. That would be
If
great.
you are a lawyer, if you can't say it on the record, don't say it off the record.
Huh. Well,
No,
that's.
please do. He's wrong.
You know, and we can quote you, Stuart Jones, as always saying that you never speak off the record. That's fine. No lawyers ever do. But Casey Seiler, what do you think about this notion of off the record and on background? And what do those terms mean anyway? And how do you know that they mean the same thing to one person as to another?
Well, I mean, whether it's a contract or not, contracts are, of course, about specific languages, and the contracts exist so people understand the relationship and the mutual benefit to two parties or more. The problem with those terms and those practices is that quite often the definitions, they're not written down anywhere. You know, there's no, you know, the Society for Professional Journalists has those definitions on their website. I don't think anybody really consults them. Our understanding, to be clear, the way that we operate at the Times Union under Rex and under me is that off the record means it is off the record. Whether or not a journalist can use the information that is conveyed in an off the record discussion is subject to an agreement between the source and the journalist whose anonymity is being protected. So in other words, the source can say, this is off the record, you can use this information and call around and try to get it authenticated with other sources. That I think would function as, I think Bob Woodward would use that as deep background. Deep background is, this is not for attribution, you cannot use this, but you can take the information and attempt to authenticate it in other places. On background is very different. The way, at least the way that we use it, is that it is on the record. Anything that is said on background is on the record, can be quoted, the information can be used, any numbers, any facts are usable for printing in the paper, but there is a prior agreement as to how that information will be attributed. So for example, a senior executive chamber source said X, you know, the virus is now spreading in wildly across upstate counties, according to a DOH spokesman or spokesperson. So that is on background. That I hope that, and then of course, what we hope is for on the record. On the record is everything that comes out of my mouth or that I send to you is usable. Frequently, we will get people who will send us emails or begin conversations saying, this is off the record. I'm sending you this off the record. And our response is, no. It's got to be a two-way agreement. It's got to be, in effect, a contract, not in perhaps the legal sense, but at least in the professional sense.
Yeah. And to Mike Greigel's point, the difficulty comes when you're actually in a conversation with a source and the person starts to tell you something and you say, wait, no, I can't talk to you about that. You can't talk to me off the record. That's very hard to do. I mean, we've done it. I heard Casey Seiler say to a mayor of one of the major cities here in the middle of an editorial board, no, don't speak to us. You cannot tell us this off the record. And I always wonder what he was wanting to tell us.
I worked along with Chris Bragg, one of our investigative reporters, for months on an investigation. And I think 3 days before publication, the person we were writing about, a real estate developer, called up and said he had made voluminous contributions to the governor and it would appear that he had gotten special consideration. And he said, look, I want to talk to you and tell you the whole story, but I've got to do it off the record. And I remember walking into your office and saying this and saying, oh, geez, this big Sunday story is going to be scotched. And I said, I don't want to talk to him off the record. And you said, yeah, no, he's the target of the story. We're not talking to him off the record.
Yeah.
So
Yeah. You gotta.
I think Casey just presented a very detailed and accurate recitation of the conventional understanding of the different approaches off the record, on background, for attribution only. The difficulty is the news organization and the reporter understands that, but does the source always understand the distinctions? And often they don't. And again, this is not a context where a reporter is necessarily going to pull out a 5-page document and say to a source who's about to spill the beans, can you sign this before you tell me anything? That's just not how the process works.
I think in my experience, there are times when there's a bilateral, clear understanding on both sides that something is off the record. I did this the first time with a little bit of trepidation, but it worked out fine. I always felt a little bit uncomfortable as a county judge when there was about to be a guilty plea, and everybody would adjourn into chambers. There'd be discussion about how the plea was gonna go down. Then we come back out in the courtroom, and the press felt like there's some dark secrets going on inside in the judge's office where the parties were discussing it. So I said to one of the local reporters, look, if you want to come in I feel very uncomfortable that you think there's anything suspicious going on. If you want to come in and watch the whole proceeding, that's fine. But if you agree not to report on it, because if the plea breaks down and then the person goes to trial, we don't want in the newspaper this discussion about how the person's going to plead guilty. And the reporter said, fine. We never had a problem. It was never reported. It was never betrayed. And it built up some trust and confidence on both sides. So my question is this. Let's suppose it was breached by the newspapers and they broke it down. The trial court or the lower court in Minnesota said this is a contract that's actionable when breached. But for some reason, the Supreme Court in Minnesota said it's not actionable. What was the theory of the Supreme Court saying that a breach of this kind is not actionable? As a lawyer, I want to understand what their premise was.
I haven't read the opinion in quite a while, Judge Rosenblatt, so this needs to be qualified, hedged, to use a different word. But the argument was that ensuring the free flow of information to the public on a matter of paramount public concern and interest, such as a gubernatorial election in the state of Minnesota, overrode an alleged breach of an oral agreement between a reporter and a source. Now, when the decision went from the Minnesota Supreme Court to the US Supreme Court, it flipped back. The US Supreme Court held that there was some type of enforceable legal obligation between the reporter and the source, the enforcement of which did not violate the First Amendment. So
Wow.
that,
Oh,
which is
boy,
of course,
Okay.
why it's so important for news organizations to have clear policies in place and understandings with their in the field reporters about what is acceptable in the context of a reporter-source confidential relationship.
Wow. Oh, that's interesting. I didn't know it had another chapter. So I guess, we didn't plan on having takeaways, but the takeaway that I get out of this is that if the journalist does want to hear something off the record, that should be made very, very clear. And if the journalist does not want to hear anything on the record and not be bound by silence, the journalist will say, hey, I'm sorry. I'm not on the off the record business. Everything you say is on the record. And that way it's clear.
And we should be clear though, Judge Rosenblatt, that in this context, there's a substantial, even overwhelming incentive for the press to live up to these obligations, because in the event that an editorial decision is made to override a reporter's promise of confidentiality to a source, that reporter is going to be immoderately unhappy because their professional, sometimes even personal credibility is on the line. So it's something that rarely happens. And if it were routine, sources would not talk to reporters. The free flow of news and information would dry up.
Very briefly, for those who are online seeking CLE credit, the first code word is libel. Again, the first code word is libel.
I'll just do one more thing here on this. On this point, is very interesting to DA Donnelly and to Judge Little. This model, the judge, it was when you were a county court judge that you actually brought the reporter into chambers for these pleas. That's really interesting. When I was a young reporter covering courts in Suffolk County, New York, the Felony Screening Bureau would let me look at the case files before they would go in for arraignment in the morning, with the kind of understanding that I wouldn't abuse the privilege, I guess. But and I was in and out of those offices. I don't know if that kind of behavior still goes on. Can you talk about that? I don't know. Does she? Yes, please.
There we
you
go. Can you hear me now? I've seen a real shift over the last 25 years. I began in Albany City Court, and we had an unwritten policy of engaging with the press as much as we could to try to make sure that what was going on was accurately depicted to the press. And we had very good relationships that we built. But one directive that I was given, the same as Mr. Jones stated, was if you can't rely upon this, that you will get burned if you say the wrong thing. But it goes both ways. Freedom of the press, you're free not to speak. So if we speak, we understand the threat of it. In the court where I began, there was a real, I think, a collegial relationship with the press that we attempted to be as forthright as possible. Quite honestly, I think I saw over the years administratively with the Office of Court Administration, there be a more strict policy that was expected to be followed with the courts. Now that I am a district attorney, it's different because I have an obligation to be free with the information so that my constituents and the public understand what's going on. But I have to recognize public safety, and I always have to think, do I want my feeling or my opinion on something to be published? So I've come to a point where we do have a trust with the press, but I think we're all a lot more cautious than we were 25 years ago. And that's not a commentary on our local press at all. I've tried to maintain a good relationship with them, and I do favor informing the press as much as we possibly can while protecting public safety.
And Judge Little, do you have do you feel ever that you wish you could be more free with talking to the media about what's going on in your courtroom?
Well, so the good thing about my job is that we're not allowed to talk to the media, especially if it's a case.
Is that
in
right?
Court. Ethically, we're not permitted to do that, so it makes my job a lot easier.
I don't know that that's true. You think so?
I know, so thank God. It's one of those things I'm happy about for the most part. But I will say that, first of all, most of the stuff I do, as opposed to like some of the conversation we just had, is on the record. Right. So, and for me, having things on a record means that whenever someone wants to look at it, all they have to do is grab the transcript and take a look at it and read it. Now, I won't say that we don't have those conversations that take place in chambers, because that's where a lot of the deals get made in a sense of what we're agreeing to. And in the context of the media, as far as bringing the media back, I have had media back in chambers before when we are discussing what will happen when there's an application to have court cameras in my courtroom. So over the short period of time, I've only been elected since January of this year, but I've probably had media in my courtroom maybe 15 or 20 times on different cases. And so I've had the opportunity to discuss with media, and a lot of it is to the discretion of the trial judge in these contexts. When you're allowing or making a determination as to what the application or what you're going to allow as far as recording in the courtroom. In that context, I will bring the media back and say, this is what I think, because I'm concerned, as someone mentioned before, I think it was Judge Rosenblatt said about the administration of justice in the courtroom. It's a different function than maybe what the media is thinking about. But I will say that the media that I've had the pleasure of working with thus far has really respected my position on media coverage in my courtroom and the restrictions that I place, whatever it may be, depending on the circumstances. If it is a sensitive case, there may be more restrictions. If there is not, I may allow you to, the media, to film in the courtroom more freely, as far as having the person walking out, maybe capturing some of the back and forth colloquy. But when there are very sensitive cases, and if I think that there's going to affect the administration of justice, which is my main primary concern in my courtroom, then I may restrict or limit what can or cannot be captured. But long story short, I have had media back in chambers before to discuss the limitations and restrictions of cameras in my courtroom.
It is interesting that you've done that, because I didn't know whether you would wince when I was describing that I would sometimes have the journalist back there. We were never burned. You're wincing. Okay. Well, yeah, well, we were never burned. It never saw the light of day because it, I think, furthered something that is intangible here. That's part of this overall paradigm, and that is that the element of trust. I thought it built up trust. I could trust them and they me when they saw there's nothing weird going on in the back room, and I could trust them not to report it. That we were never burned. I remember akin to that, Alan Greenspan got up at a graduation ceremony before thousands of people. He was the head of the Fed, and he was like, the great economist in the country. And he pointed out that thousands and thousands, if not millions, of deals in the United States, the overwhelming majority go down on a handshake. And that's how business is done in this country. And this is sort of a first cousin to that. It's a handshake. It was never breached. And I think that's something that sort of enters into this whole discussion just sort of sideways, but it's something that it was one of my takeaways. Okay, the next chapter of this diabolical hypothetical takes place when the media swarmed all over Cambridge County, and a lot of the reporters reached out to Dr. Faust, and he at that point declined to speak further. He protested what was going on, and he said that his conversation with Digger was off the record. And the doctors in other nearby communities explained that they too were noticing a lot of dangerous flu, and the story took on a life of its own. Some news sites linked to Digger's articles, but other national outlets repeated Digger's reporting without attribution. And that may be of some consternation to the media folks, and to the great frustration of Martyr Media's business executives. So my question to the journalists is this: what recourse do you have if a story is developed and purloined by another news organization? What about rewriting your copyrighted material, which is nowadays a common practice? So what recourse do you think we have on that? We can ask the journalists if anybody would like to comment on that. Would you?
So we don't have very many recourses at all. I mean, it's a violation of copyright law for them to cut and paste our entire article. But under fair use, they can take a couple of paragraphs and maybe add a different headline. It's totally okay. I launched efforts to try to rein in copyright infringement, but it's a lot of work. It's a lot of legal expense, and it's really not worth the effort. It's almost become commonplace nowadays for someone to write an article and for it to be spread all over without attribution. Sometimes they'll do you the favor, they think, of linking to your story, your original story, or attributing it to the original source. They think that's giving us something that doesn't usually give the originating paper anything at all. So it's almost something we've come to expect and live with. And what we'll see is we'll write the big duck blue story, and it'll start in a local small newspaper, and the next day it'll be on, NBC News, and they will get all the clicks and shares and all the that's how it works. That's modern day journalism.
Susan Arbetter, you're a television journalist, before that a radio journalist, and you probably have encountered this a lot, where what you put out on the airwaves gets picked up. And so it's not only, since you've been working some in, well, no, you're in private media now, so there's commercial element to this. Does this, do you do anything about it ever?
No, I mean, there's some reporting I did for NPR at, for example, Woodstock 99. This is, showing my age, but it ended up in an HBO special on Woodstock 99. There's nothing you can do about it. And it's fine. It's sort of a point of pride. But we here at Spectrum, we do a blog that Nick Reisman is the author of 90% of. It's called New York State of Politics. And we realized that there was a central New York newspaper that was copying and pasting almost the entire blog on a daily basis without any attribution whatsoever. We realized it was a young journalist who didn't really know what he or she was doing. And a quick phone call to her ended with a little bit of her shame and it stopping the practice. So sometimes it's just that, we have so many fewer journalists than we did in 2006. We have something like half the number of journalists, and they're all right out of college. They're paid almost nothing, and you have to fill 24-hour news cycles. So it does lead to some shortcuts being taken sometimes.
But Mike Greigel, there's a downside to this. If that content proves defamatory, doesn't liability attach to those who republish, especially if it's done without attribution? Isn't there and is liability lessened if a news organization attributes what may be defamatory content to the initial source of it.
I can think of circumstances where that argument can be credibly made. However, to provide blanket insulation from republication authority simply because breaking news is being published by another news entity or organization. If what the original publisher puts out into circulation is actionable, there's no real defense to simply saying, well, it's already out there, so we're going to pick it up too. There is a doctrine that actually I believe in, and I think it should be rehabilitated, called neutral reportage, which says that if you have a very compelling news story, it's in the public domain, reputable news organizations are covering it, then others can as well. Because news is the news, the public has a right to be informed. While gaining some traction back in the late 1970s, that doctrine has now routinely been discredited by most courts. So if you're going to republish information without doing an independent verification yourself, you do so and assume the risk of whatever liability exposure may result as a consequence.
Don't republish Fox News.
Or even worse, you know, that actually this goes to the question of what is journalism these days, because there are so many sites and indeed now print publications that mimic journalism that are in fact funded by partisans, that it does raise a question: does any protection that the law has provided to journalists attach to people who don't share the ethical standards of people who attend the New York Fair Trial Free Press Conference?
Note the important qualification in the neutral reportage doctrine. It's where the information is being reported by a responsible, acceptable news organization. Now, that definition, of course, introduces what might be difficult line drawing issues, but it's a very big thing for CNN to go on the air, and this is just purely hypothetical, and say, the New York Times is reporting that President Biden or another government official is doing this. It's a different thing altogether for CNN to go on the air without independent verification and say, Joe or Jane blogger in their underwear in their basement is putting out the information, and here's what they're saying. So the doctrine, which again has largely been discredited, would certainly not apply in the latter scenario.
Okay, well, let's just imagine this going forward, and the governor of New York, who, in the unlikely event that person is a candidate for the Republican Party presidential nomination, denounced the whole notion of an outbreak, reckless reporting, and frankly, awful medical practice by Dr. Tommy whatever, referring to Dr. Thomas Faust. The governor said citizens of this state have nothing to worry about from this bug, and they ought to ignore lying media and quack doctors. So the doctor, who has been quoted, first says he is misquoted and didn't want to be quoted in the first place, contacts his lawyer and insists on suing the governor, the Bluford Bee, and the reporter for libel. So I guess the question is, let me ask Stu Jones this, and you can put on the hat of plaintiff lawyer here. If Dr. Faust comes to you and says, counselor, I want to sue the governor, my local newspaper, and this reporter, are you going to say there's any likelihood of success in a lawsuit against such individuals?
In New York, Democratic state, I would say that the attribution of incompetence to the doctor, that's a challenge to his professional qualifications and integrity. That could provide a basis for the libel action. He called him, as I recall, a quack doctor, attributed later on in the release that you put together, they attributed deaths to the management of patients by these doctors. So I think it's a valid case. It's narrowly focused.
Against the
Against the governor.
the governor's,
I think that goes way beyond political hyperbole.
Counsel for the defense on libel, do you think that's true?
Well, I'm loath to disagree with Stu Jones about anything, but disagree I must. I think the language that's involved here indicates that this is exaggerated opinion, nothing more than figurative rhetorical hyperbole. Is it disparaging to the doctor? Yes, it is. There's nothing said here that accuses him of any direct unprofessional conduct or certainly of any criminality. It simply says this is awful medical practice. He's a quack. That inherently is a subjective expression of opinion that is unverifiable as opposed to a false statement of fact, which is potentially actionable.
So Stu, when you said that the doctor has a gripe when the doctor's professional qualifications are called into question, defamation, he's been called a quack by the governor. My question is this: would the governor be treated under the law exactly as would someone who is not the governor? Is the governor held to exact same standard as a defendant, or does the governor have a little bit more leeway to say things given some sort of privilege of some kind, which I cannot yet describe, but I'm asking you that question. Is the governor a little more free to say this than the ordinary person on the street?
Not my judgment. I think if the case were to go to trial, they would hold the governor to a higher standard, actually. Obviously, actual malice standards, a tough standard in defamation cases, and to build a case that demonstrates reckless disregard for truth. I think this governor was prone to reckless disregard for the truth.
You think there was there's a case under ordinary defamation law? You think it's actionable?
I think it's a case that should be brought. I think it's a case that would require depositions.
Yeah.
The standard for success ultimately is very high. Summary judgment motion is going to be filed, relying on Times case. But this governor is reckless.
Yeah.
And one of the tests is reckless disregard
Right.
for the truth or falsity of the statements.
Right.
No foundation, no credible foundation, no factual foundation for
Right.
any of the statements he's making about this doctor. And he's attributing this doctor to a person who's causing great harm
Right.
to patients throughout the state of New York.
Would the doctor qualify as a person, a public figure within the framework of Sullivan against the Times?
No.
You agree?
I think it's a close call. What matters, to be clear, is not the status of the governor as a defendant, but the status of the plaintiff who's bringing the libel case that determines the controlling standard of constitutional fault. So if Dr. Faust qualifies as a public figure, then he has to prove actual malice, publication with knowledge of falsity or reckless disregard thereof. He doesn't seem to be a general purpose public figure in the hypothetical. I think that would be a real stretch. The question is, by commenting to the press, did he inject himself into the swirling controversy about the duck flu and thereby achieve the status of what's known as a limited purpose public figure, in which case he still has to prove actual malice in order to demonstrate liability for defamation.
In as much as doctors are licensed by the state and the governor is the chief executive of the state, there is, I think, some to Stu's point, there might be some concern that the attribution of quack to this state licensed doctor by the chief executive of the state could be fairly significantly defamatory, I would think. And then it goes on from there in our hypothetical. The editor of the Bluford Bee gets a little bit whacked out here and says, who's previously referred to the governor as disastrously underqualified, publishes an editorial, "A quacks like a pandemic, doctor." And so the editorial, which doesn't do any reporting beyond what the editor has read in the paper, imagine that, says that Governor Sykes knows there's a dangerous epidemic in the state and is covering it up for political purposes. The governor's inaction surely cost the lives of needlessly unprepared New Yorkers. The governor calls a press conference, says he's liable, he's fed up with it. It is a malicious lie to claim that I knew of any outbreak. We all have to stand up to the lying media. He asked the state attorney general to investigate the Bluford media. The governor's personal lawyer suggests, by the way, that the libel standard established in Sullivan v. Times was outmoded and unfairly hamstrings honorable public servants who are defamed by reckless media. So, you know, I might ask, are we in a position where it might not hurt for a high-profile public official to bring a case that treads the line of Sullivan, given some of the hostility to Sullivan expressed by U.S. Supreme Court? Do you think, Stu Jones, that might be therefore worth the governor stepping forward?
Not this governor.
Well, you know, you wonder about if the governor's outrageous claim that the doctor is a quack might be actionable. Donald Trump consistently says things a lot worse than that all the time. No action is ever brought against, well,
Lots of actions.
Donald Trump is one of the most frequent serial defamation plaintiffs this country has ever seen. He sued the New York Times about 10 years ago because they reported he was not as wealthy as he claims to be. And in his deposition, and I've read the transcript, when he was questioned, the real issue is how do you determine your net worth and your day-to-day wealth? At the end of the day, here was his answer. It's how I feel when I get out of the bed in the morning. To me, that is a frivolous lawsuit. And if I were the judge in that case, I would have sanctioned Trump, maybe even his attorneys, for bringing a case that so clearly transgressed not just direct First Amendment principles, but cultural constitutional norms that have governed our society for 200 years.
You know, there's another little piece to this that I think is interesting, which we maybe have witnessed over the last 3 or 4 years. And I want to ask, I mean, if this is too delicate, then just say you don't want to answer. But as a former United States attorney, what happens when the executive, whether it's the mayor who asks the mayor's attorney, the city council, the city attorney, when the executive asks the executive's appointee to investigate something, and the executive's appointee is supposed to, at least on paper, be independent. So what happens when the executive branch says to the United States attorney, you know what, I want this investigated. And the subtext is, by the way, I appointed you.
So very different federal state, right? So the United States attorney, certainly the attorney general can direct investigations or direct priorities in the U.S. attorney's office. I mean, so can the president call their attorney general and ask for an investigation of something? I think you have to step back and not see that in the political context where we've kind of been operating in here. So what if the president calls the attorney general and says, look, I'm really concerned about price gouging under the current circumstances, and I'd really like you to look into it. Is there anything wrong with that? I mean, what's wrong with that? I don't think so. I think the attorney general can say, great, I'll look at it. And they do an above board down the line investigation. Does it change if the attorney general is your brother? I don't know. There's all kinds of different things at play there. I think the underlying subtext here is you're asking your appointee to take action against a political enemy. And that to me is not so much an authority issue in terms of can I do something if I'm the president, but am I abusing that power in an individual case? In New York, you have a very different situation. And I think this is more of a state hypothetical because you have kind of a horizontal federalism thing going on. So the attorney general is elected. They're an independent constitutional officer. So the governor, I would think, can call the attorney general and say, I'm concerned about Medicaid fraud, or I'm concerned about X. I think there's different rules then, or different operating principles for an attorney general in New York. Same with district attorneys. I mean, district attorneys are independently elected constitutional officers in New York. So there's really no straight line or appointment line for a district attorney to a governor or even to the attorney general, very separate and very different jurisdiction there. So I think, you know, if you look at it, you have to look at the system you're operating under, and then you have to look at what's the request. So, and analyze whether it's appropriate. But as a general matter, do I think, you know, in a chief executive asking their chief law enforcement officer to look at something, you know, no, unless there's something else going on.
Very briefly, for those of you looking for CLE online, the second code word is appear. The second code word is appear for those of you looking for CLE online.
Okay, so we've got a libel suit though progressing, or at least filed, against the governor. I'm sorry, Sykes, I've got the governor that is suing the newspaper. Here we go. We got to figure out who the plaintiff is here. And the governor promptly adds large digital sites to the libel suit because they have republished this editorial that took a slap at him. His lawyer, the governor's lawyer, says the national exposure of this malicious attack on the governor at the hands of Marxist influenced big tech companies seeks nothing less than the governor's ruination. So the governor's lawsuit sought an injunction requiring the Bluford Bee and other defendants to take down the editorial from their websites. So we might, that might have started at county court. Do you think there might be any grounds for a demand that this allegedly libelous material be taken down? Would you conduct a hearing?
Well, luckily, that wouldn't come before me in my county court position. But whether I would conduct a hearing,
Right, probably have to be state supreme, wouldn't it?
it would have
Yeah,
to be state supreme.
yeah. Well, you can answer it anyway because it's probably your next job.
I love county court. Let me start by saying that I love county court. That's why I do criminal as opposed to civil. In context of whether or not I would do a hearing, I guess it would be in the context of maybe a 78 proceedings or Article 78 proceeding or some form like that. Maybe if it was, I mean, obviously I would have to conduct the hearing to make that determination. I think in the context of the libel slander case, at least what I understand is that they're mainly started at least in the point of national action. Is that correct?
Correct.
Right. So it would probably get to the point of, for my civil, I was a civil litigator in the past, but obviously I think what Mr. Jones was saying is where it would come to the point of where I would start to make that decision is at the point of summary judgment motions to hear the case. I guess if there was a motion to dismiss at the initial phase, maybe, then I would have that option. I would probably definitely hear it out because I think it is based on facts and facts law. So,
You know, I think we're certain.
Can I weigh in just, and I think your response, Judge Little, indicates, as any good judge would, in concern about fairness to all the people involved in the situation. And if you have a hearing, get the evidence, let it come in, and see where the facts lead to the legal determination. But any attempt to get an injunction to take down published information is a prior restraint that's presumptively invalid as a matter of law under the First Amendment. So the Supreme Court held in the Pentagon Papers case that even the government's high-level government officials traipsing into court with affidavits saying, if you publish this, it's going to irreparably compromise national security. That wasn't good enough. So it's really a non-starter for a libel plaintiff to think that they can come into a judge and say, I want a court-ordered injunction banning that information from continuing to be published on the web. Simply not a viable option under our free speech regime.
We're talking about near against Minnesota, prior restraints.
Near Minnesota, all the way
Sure.
through the Pentagon.
Sure. You know, we're touching on something that strikes me as an interesting background question, and I would ask that anyone here among us, and Susan Arbetter as well, might consider this. In a perfect world, we want a free press to be as free as is plausible, free as possible. But there have been limitations, and the criterion is worded in Sullivan against the Times. Would anybody here change a single word of that case? Is that case about as perfect as can be drawn? We've been living with this criterion now for a few years. You may have different views of it. Is there anyone that would think it needs any kind of fixing if it's not perfect? And if so, how would you change it and how would you fix it? Susan, do you have any thoughts about that, or anybody else?
I wouldn't presume to answer.
Okay, anybody?
Justice Thomas thinks it should be modified.
Are you speaking? I'm sorry.
Supreme Court Justice Thomas thinks that Sullivan should be modified.
He would allow libel suits more freely.
That's correct.
Do we know what standard he would create if he doesn't like the notion of false or recklessness? What standard would he put in? Just ordinary defamation?
I have no idea, and it's well beyond my competence to
Right,
look into his mind.
Judge Rosenblatt.
Anybody?
And I ask the panel's indulgence on this. This is going to be kind of a long answer, but I hope it will benefit the students. And at the risk of monopolizing the discussion, New York Times v. Sullivan's decided in 1964, it's become not just a lodestar of our constitutional system of adjudicating First Amendment cases, but it's become really a culturally valued norm. And in 2019, Justice Thomas, as Judge Rosenblatt said, issued an opinion in a case called a denial from certiorari in McKee v. Cosby. And the facts there were kind of interesting because McKee was one of the women who came out publicly and identified herself as being one of Bill Cosby's victims. Cosby and his attorney excoriated her in the press, said she was a liar, said she was fabricating everything. She turned around and sued for defamation. So her case gets thrown out because she can't meet the actual malice standard, which some people thought was demonstrably unfair in that context. Goes all the way up to the Supreme Court. They deny cert. Justice Thomas comes out for the first time and says, we should reevaluate New York Times v. Sullivan. It deserves recalibration. Let's see if I can find his language here. Thomas states that Sullivan and its progeny were policy-driven decisions masquerading as constitutional law, and that the First Amendment, when it was drafted, go back to the time of the framers, was never understood to require actual malice in a defamation case. So his theory is, let's hand it all back to the states. It becomes a state tort law regime with no constitutional safeguards. In some ways, reminiscent of what the Supreme Court did in Dobbs during the most current term. It's no longer a fundamental right of privacy in that case. We're going to dump this back to the states, remit this issue to a matter of majoritarian political preference. So when Thomas issued that opinion, I think most of us in the immediate defense bar were not that alarmed. We considered it an outlier. Didn't think it would get much support. Fast forward, 2 years later, Justice Gorsuch issues an opinion dissenting from a denial of cert, also saying we should revisit Sullivan. His theory is very different than Chief Justice Thomas's, which is let's go back and do what the framers did in the good old days. And they didn't think or care about actual malice, which is debatable, by the way. Justice Gorsuch's theory is the whole economic model of news reporting today has changed. When Judy was the editor of the Schenectady Gazette, when Rex was the editor of the Times Union, Casey, I'm sure you still have this intact today, you often have a reporter in the field doing their reporting. There's a supervising editor, a managing editor, all looking at the copy before a story ever gets into print. After it goes through those 2 or 3 layers of review, it goes to the copy desk for additional review. Only then does it go into print. Gorsuch says that's not the way it works anymore. There's this incessant, perpetual 24-hour news cycle with the advent of the web. The news economics have changed. Newspapers and other publishers don't have the economic ability to staff their newsrooms those ways anymore. What happens is you have people just out there claiming to be news gatherers and bloggers, getting information and throwing it right up on the web. And that system, which was not in place in 1964 when Sullivan was decided, actually incentivizes reporters not to know, because Sullivan then will largely extend them protection. So Gorsuch says, for that reason, I'm joining my brethren, Clarence Thomas, and we think Sullivan should be recalibrated, if not entirely overruled. Justice Kagan, when she was a law professor at the University of Chicago in 1992, wrote an article in which she too was critical of Sullivan as being overbroad. She didn't advocate its repeal, but she said, maybe we should rethink the scope of these protections that we've offered. So
Rethink and what? And do what?
well, it wasn't entirely clear about that. I think she would
You
have.
gotta be
left-
clear.
I think she would have left Sullivan intact, certainly with respect to government officials. It's a question about whether it would go to other public figures. But it remains to be seen. But the point here is, it seems to me, what I would previously have dismissed as a glass 7/9 full, I'm not so sure anymore, given what happened with Dobbs during the past term and the court's willingness to revisit what most people would have viewed as settled precedent. And I can only say that if Sullivan is significantly curtailed or overruled, I would love to hear from Casey and Judy and Rex about how their jobs would have been different.
Well, it's hard for me to imagine that Times Against Sullivan does not have a dimension of a federal question under the First Amendment. To me, that's unfathomable. But if, as you say, one's supposed remedy is to go to and throw it back to the states, A, we'd have 50 different standards, or B, maybe not 50 different standards, because the states, in all likelihood, would fashion their own rulings from the state high courts, which would probably be very much like Sullivan against the Times, or provide even greater protection because states can provide greater protection than the federal. So I don't know that that's going to remedy very much. I guess I'm giving away my own thought that I think it's about as good as we can get, but that's not for me to say.
If I may, I would just say, I mean, one impact of that would be a whole lot less newspapers and a whole lot less journalists at the newspapers that exist, because the legal costs of running those operations would likely go through the roof. And I think it's also important to remember that under Sullivan, you are increasingly seeing actions being brought. I think everybody is paying close attention to the case that's brought against Fox News by the election machine. Was it Smartmatic or Dominion?
Dominion,
Yes, that's right. That I think puts that very much to the test as to whether or not Fox, much like Alex Jones, can retail fabulism and conspiracy theories without serious legal consequences, financial consequences. And the fact that not only Fox News, but also the parent corporation are defendants in that case is a serious threat that I think is a good one, in the sense that it is calling that news organization to account.
Well, that's interesting to hear a journalist say that a libel suit against a journalist organization is a good one. Mike Reigel, you've spent a career on the side of the media. This case against Fox News is based upon Fox News, in effect, violating the standards that your clients try to follow. The media bar, I would imagine, is fairly divided about this matter.
I think so. But again, I think this only reinforces the propriety and advisability of retaining Sullivan as a fault standard. But I have not had the time to read the briefs in the case, and there's been extensive threshold motion practice under Federal Rule 12b-6 in all of the cases, the Michael Lindell case, the Dominion cases, the Smartmatic cases, all focused on the application of New York Times v. Sullivan and actual malice. There has been a great deal of commentary in the press from reputable observers, including First Amendment lawyers, that seem to think there is meaningful liability exposure to Fox based on its reporting in this case, meaning that there's enough evidence to satisfy actual malice. So again, to me, that indicates that where there are, and I'm not saying that there are in this case, I think the proof has to come out, but Sullivan in a case can be met. The standard of proof can be met. It's not an insuperable hurdle to a defamation plaintiff. And one other quick point that I want to make for the benefit of the students, most of you probably know about Sarah Palin's libel case against the New York Times that garnered a great deal of publicity, went up on appeal to the Second Circuit. The case was thrown out. It went to trial, which is very rare to have a defamation case go to a jury, even more rare for that to happen where Sullivan is the fault standard. She filed her appeal in the Second Circuit September 19th, just a couple of days ago. The lead argument in her brief is, let's get rid of Sullivan. So there is traction developing in arguments by the plaintiff's bar to try to overturn the protection that has historically been afforded by New York Times v. Sullivan.
Can I just say that without Sullivan, you're going to have a lot less accountability journalism and a lot more bad government. It will have the classic chilling effect on newspapers because a lot of them are struggling financially and they can't afford to even consider being sued for libel. So they're going to back off doing that investigative piece. This is as they say, it could be an existential crisis for local journalism.
Let me ask you something else, Judy, while you're there. I mean, if Judge Little is not going to go along with this takedown order that the plaintiffs are seeking, that the governor is seeking, but let's say that you have material that you've published that is problematic, would be a nice way to put it. Under what options would you consider a takedown of objectionable content from your digital archives?
When you were first talking about the idea of a judge ordering a newspaper or any other media company to take an article down, I thought that was, I don't want to live in that world. So you would have to I would go kicking and screaming before I would take anything down.
Casey Seiler, aren't there times when you might take something down from timesunion.com?
Yeah, yes, if it's proven to be in serious error. I can think of times when we have taken a story down that is digitally spiked it. I can count them on one hand with a couple of fingers already chopped off. And far more frequently, especially these days, we are getting requests to take a story down that concerns, for example, a minor crime from years ago, 5 years ago, 10 years ago, or even longer. A nasty DUI arrest, a barroom brawl in which in the past we would have regularly sort of just taken the police report as a police bulletin item and published the names of the arrestees and thought no more about it because it was going to be in print one day and poof, it was gone. Now, of course, if you Google the name of that arrestee, even if their case is 15 years old, it still exists as a digital blot on what might be an otherwise completely respectable life. So probably once a week, at least, I will get an email from somebody saying, I was arrested in 2008. I went on to college, went on to law school in some cases, and I'm now a young parent. Could you please, take this story down? Unless it is in grievous error, we will not take the story down, that is just disappear it from the internet. What we will do is known as de-indexing the story. There is a process that we can put the digital file through. Please don't ask me how it works. I think that the internet is run by tiny little elves who live inside my phone. But, and that will make that story largely invisible to web searches. That is not a perfect system. There are still web crawlers that will suck up everything that has ever been published. So it might exist in some database somewhere, but I have never heard complaints subsequent to the de-indexing of a story from someone who is still, bothered by it turning up on the web. And we have a process for that. Obviously, it's going to be a judgment call. Violent crimes with victims, the crimes that are above a misdemeanor, we have to talk seriously about whether or not we are going to de-index them. In other words, if somebody is charged with sexual assault or forcible touching 5 years ago, and that person is a lawyer or a doctor or is dating again or something like that, is that something that you want to remove from the public record? Is that something the public deserves to know? We have to balance the public right to know against the individual's right not to have every woeful act in their past chase them for eternity.
I have clients who live in eternity in press stories, even though they were acquitted. But is taking something down the equivalent of a retraction?
No, oh God,
So,
no.
but tell me
No.
about retractions.
Retractions are different. Retractions are when we actually get it wrong. I'm not talking about that. I'm talking about cases where we got it right. We noted that somebody was arrested, and yes, indeed, they were arrested. That is, we are reporting true facts. That is very different from a retraction. A retraction would be sort of the ultimate sanction for a news story in which we are saying we are no longer confident of this story as it was reported. We take it back. Boy, I can't think of, we run corrections all the time, but a full-on retraction, can you think of one? I can't think of one in
I can't think of one in my career.
Far more extensive tenure.
I'm far older. I don't remember any news retraction in my career. So, if your clients want that, they're unlikely to get it. And I think that's actually largely because what's reported is true. Don't anybody throw anything, okay?
Client can't afford to perpetuate the controversy.
Uh-huh.
And it just continues, so.
But a murder defendant, for example, we're not going to de-index stories about a murder case that included investigation, arrest, arraignment, trial, verdict. Even if the verdict is not guilty, we're not going to go back through the files and de-index all those stories for the good reason that your client, if it is your client, deserves to have the story of his acquittal in the public record as well, because not only
with the last story about
if it were,
but
yes,
sometimes
exactly.
it's not.
Hopefully he's not rearrested, but yeah.
So anyway, just to go back to the hypothetical for a moment and take a whole different direction here, Governor Sykes has signed an executive order limiting public assembly, restaurants, bars, entertainment venues, limited to no more than 12 people, religious services where music would be played or food would be consumed, homeless shelters, grocery stores. All of this is part of the governor's executive order. And pretty soon there comes a lawsuit to stop enforcement of the governor's order. Congregation Holy Word, the claim that it violates their First Amendment rights. Church of Freedom, that was founded the day after the governor's order, says that they have a similar argument. And then there's this group, NYSROK, the State Association of Restaurant Owners, claims that the order is arbitrary based on inconclusive data. And I guess a question would be, Stu Jones, if you want to overcome the governor's executive order, if you are counsel to the plaintiffs, the Restaurant Owners Association, or the churches, you might be hired by this fine new church that's just sprung up, the Church of Freedom.
I think that's unlikely, but.
Yeah, what are your best arguments to overcome the governor's executive order? Can you think?
I'll defer to Mike Greigel on that issue.
Would you be able to, would you think you could overcome the governor's executive order?
I think if the answer might have been different before the current composition of the US Supreme Court changed. But I think the business organization is going to have a tough time. to me, this is just economic legislation. It may have a difficult impact on certain business owners, but it's undertaken under general police powers. As long as there's a rational basis for the legislation, it probably withstands any type of constitutional scrutiny. The religious freedom claim stands on a bit of a different footing. And I know there were several of these that went up to the Supreme Court, a couple on the shadow docket during the pandemic. And I think originally the government restrictions were upheld. And then as I recall, there was a challenge that was to a restriction on religious worship services that was found to violate the free exercise clause of the First Amendment. I think there, again, my memory here is probably fallible, but there was a difference in treatment between the religious groups and I think other affected organizations under the legislation. So here I see the numbers are the same. Potentially that could impact the outcome. But the one observation I have about the current Supreme Court's free exercise clause jurisprudence is that it used to be that free exercise claims were usually brought by marginalized, albeit sincere religious groups on the fringe of society who were differentially impacted by a generally applicable government law and brought a challenge. Today, it seems as though the majority or the preponderance of free exercise claims are being brought by majoritarian religious groups unable to achieve a certain result that they want through the legislative process. So they're turning to the court and claiming free exercise. And recently, the trend or the trajectory in the first free exercise clause jurisprudence is to find that those claims are valid. So it's a whole other topic of discussion, but if you look at the religious clause challenges that and the foundations of that dating back to cases like Engel v. Vitale, New York State case in 1962 that banned prayer in schools, you've almost gone 180 degrees. Because back in the 60s, the seminal cases said government organs cannot do this. Then there was a sort of shift in the 90s and the early 2000s that says, well, maybe they can, it might be permissive. And now in the two religion cases that came out this past term, which didn't get the attention they should have, probably because of Dobbs, but radically destabilized the traditional protection or separation of church and state. Now these decisions say the government must accommodate that religious free exercise. So we've kind of, in 40, 50 years, it's gone 180 degrees.
Good. You know, there's another issue that we're nearing the closing hour, but there's one issue that we wanted to cover because it's out there and it will happen from time to time, that whenever one of these outbursts take place, there are maybe more than one investigative agency involved. The local DA is going to start an investigation, the state attorney general, maybe the United States attorney, and everybody's convening grand juries and calling witnesses before grand juries. And you know that under federal rules, we have use immunity, and under state rules, we have transactional immunity. So I'll ask maybe the judge if you want to say anything about how agencies react when there are these multiple offices coming in to do investigation. At what point does who yield to whom, and under what circumstances would you feel that should go forward? Judge, you want to say anything, and then we'll hear from the DA.
Sure. You know, the ideal is you work it out. You look at the different authorities the offices have, their ability to get information, maybe from overseas or from other states, and that should be really a discussion about what's best for the case. How do you best approach this? And sometimes you can work together. There are ways you can make a assistant district attorney a special assistant United States attorney and work together in a federal on a federal case. Again, that's the ideal. In reality, a lot of times you have personalities on the ground. If it's a fight between federal prosecutors, there's a referee. It can go up to the Department of Justice. Ultimately, the Attorney General can referee a turf battle. Across the lines in terms of jurisdictions is a lot harder. Usually, again, you try to work that out with relationships. The federal prosecutors have one big advantage because their double jeopardy rules are better. So if the federal prosecutor can get a plea, get people to start coming in and cooperate, they can try to, and this is an extreme thing to do, but they can try to double jeopardy a state prosecution out, which again is not where you want to be. But it really, I think in the end of the day, at least across Fed to state, relies on relationships. When I was U.S. attorney, I had a very good relationship with the Bronx DA at the time. And we would talk about where best to bring, you know, for example, certain gun cases, you know, what were the penalties? What were the, you know, what were the resources the different offices could bring? That was a good relationship. Others were a little more difficult, but so I think it, you know, that way you really, you try to work it out. I'm not sure, and I defer to you on how that works with the Attorney General. Obviously, Attorney General and a state prosecutor, your jurisdiction is so different. So maybe there isn't that much turf.
Sure. It's definitely different, and we haven't really had a difficulty in where that intersection is. You know, one example that comes to mind is police involved shootings. We have legislation where we have to defer to them. And some may recall prior to the codification of that, there was some pushback from DAs in certain areas, you know, to retain jurisdiction of these matters. So an approach that I've taken, and I think a lot of my fellow DAs have taken, is again, what's going to be best for the case? What's going to be best for public perception of the case? Does it matter if I'm the one who's going to prosecute that bank robber if in fact he can get a better penalty, you know, federally? But again, if it's a high profile defendant, for example, and it's a charge that I could bring, are people going to look at me and say the elected DA is doing that for political purposes? Whereas if it is taken in a different direction, it may be better for the case. In some cases, it may be worse for the case because the argument of political motivation may be there. But personally, in my office, I have tried very hard to make sure that we, exactly as you said, Judge, we look at what's best for the case, what's best for the public perception, the public trust, so that the public can see my DA is going after this person to protect me. If you're talking about our hypothetical, you're talking about a potential pandemic that's going to stretch across state lines, you know, maybe making a name for myself is not the right way to go about it if I can defer jurisdiction to a federal agency that has a lot more resources than I do. That's another big part of it. That's not really relevant to our discussion, but the resources as we go state and federal versus a county district attorney's office, sometimes we have to just recognize our limitations and do what's best for public safety.
And sometimes the charges, right, are different. So it might be that the federal government, you know, going back to the old terrorism cases, the federal government had different tools to get at the type of conduct than bringing a murder case would be by a district attorney. And maybe you want the message of charging, you know, a particular crime as terrorism rather than a murder. Again, as you say, for public perception of the prosecution.
Right. It's going to depend on the impact that it's had on my community versus the community at large. Gun cases are a great example. Sometimes we'll have somebody that's been on our radar for a while, and then all of a sudden the feds want to come in and take it. And you're like, I finally, but then you realize the end game, it's not about me, it's about
And I've
what we can
seen
do.
in my experience as well too, having the conversations, especially when it comes to a lot of the gun cases, the murders, that really depends on really three things you'll see is the relationship, the resources, and usually the expertise of the offices. So a lot of times you will see the AG's office will come in and handle a case and work with the district attorney's office based on their resources and their expertise. And usually there is a bigger gain because the DA's office, their jurisdiction extends only so far. The AGs can reach across different counties, other side of the state. And usually, especially when there's guns involved, we see that it's not only outside of the county, sometimes it's outside the state. So then you'll see it, who handles the case based on those factors.
So practical information, if you have a client who's facing both state and federal charges and you dispose of the cases in those two jurisdictions, make sure your client is sentenced on the federal charge first, because that way they go to federal prison to serve out the sentence. So you can plead in any particular order, but make sure if you've got one facing sentencing in both courts, it's the sentencing judge in federal court, you want to go before it first. Federal prisons are a hell of a lot better than state prisons.
Well, it looks like before we close, we're going to open it up to the folks in the audience, including the students who may have some questions or observations, but not without our first thanking Dean Willett. My goodness, thanks so much for giving us the space, Judge Stein and everyone else and the faculty here as well for giving us what looks like launching a new chapter into Fair Trial Free Press. It looks like we might have a new home here. At least we hope so. So with that, I see some students out in the audience and others who may have some observations to make or questions because we covered an awful lot of ground. So floor is open.
And Zoom too, right? We can take
On
some
the Zoom
Zoom
people.
questions. Are we, note cards? If there are questions there, are we, I'm not looking at the Zoom.
I have one question submitted on the Zoom, which was specifically for Judge Rosenblatt. I'm paraphrasing slightly, but when you talked about having a journalist occasionally come into chambers, they wanted to know if you bound them by a court order or anything similar, or if it was just on.
A real good point, and that's the invisible factor here in the room, and that is pure trust. There's still room in the world for pure trust, and as the head of the Fed, Alan Greenspan, said years ago, and I still remember this was probably 20 years ago when he was speaking to an enormous crowd of graduates. 99% of the business in this country is done on a handshake. I trusted the journalist not to report it. It was not reported, and I felt that was a real that was something that I feel very, very good about. We were able to satisfy the media that nothing suspicious or untoward is going on in chambers, and I felt wonderful also that they never breached that. I didn't expect them to breach it, and they didn't breach it. So yes, there is room for that, happily, and I hope it'll continue.
Can I just say, as a journalist in relations with judges, it's always good to remember that, you know, you can write editorials about things that express your point of view, but judges, when they write their point of view, the last word they say is "so ordered." So we can tend to pay some attention to the judges and have some deference there.
By the way, Stu, I would surely have asked the lawyers, the defense lawyer particularly, do you mind if the press is here listening to the plea negotiations, et cetera? And the lawyer would have said, of course, if they're not going to publish it. And the lawyer trusted.
Not of that, of course.
But it worked out based on sheer trust, for which there is still a lot of room in our world. Yeah. Any other questions that come up for others? How about you folks? Did you have anything you'd like to say or add or comment about? Anyone?
In the back.
Question.
Discussing whether there was a piece or a libel piece struggles to language describing the doctor as a class. I was wondering, is the fact that that's not based fact change at all today, given that say things could be certain characteristics of people or media dissemination that we have today? That is there any I guess responsibility to hold those back to be published as descriptors that the government maybe has decided.
Stu, do you want to take that first? And
I'll defer to Michael, but I certainly would not take the case on the basis of the word quack only.
Mhm. It's a good question. I would stand by the assessment that calling somebody a quack or even a fraudulent doctor or an awful practitioner is not actionable in defamation because it's an inherently subjective evaluation that reflects the personal, non-verifiable opinion of the speaker. But I think your question is raising a more foundational point. In a case dating back, I think, to the 1920s, Justice Holmes once said, a word is not a crystal, transparent and unchanged. Its meaning continues to evolve over time. And that is something that the defamation law categories reflects, because for the longest time, and it's still on the books, calling somebody a homosexual and publishing that information was regarded as defamatory per se, meaning that if it wasn't true, the plaintiff who was visited with that charge didn't even have the burden of proving damages. Now, of course, the law is changing, and there have been a couple of cases in New York State. I think there's actually might be a split in the appellate level cases here in New York on this at this point, but I know Judge Mercure wrote a tremendously enlightened opinion for the Third Department, saying that it's kind of ridiculous in today's age to say that this is defamatory. Most people accept this sexual orientation. There's nothing demeaning about that. We shouldn't follow this old traditional rigid, formalistic, categorical approach to whether or not a particular ascription of sexual orientation is defamatory on its face. And I think that kind of goes to your question that defamation law has the capability to adapt to some degree with changes in social times and values.
Interesting.
Okay. Well,
Good.
by the way, Patrick Wiz does more than just give code words. He's very, very helpful. Very, very helpful in formulating this, you too. So this was a very good team that helped put together the this diabolical hypothetical. And I think with that,
I think we are out of time.
Yeah.
We didn't get all the way through the hypothetical. There are a lot of issues we didn't get to, and we can bring those up the next time around, because there are always new circumstances, new hypotheticals that can give rise to some of these really interesting conversations. So thank you. And thank you again, Dean Willett, for letting us bring this here. And to Judge Stein, who's really been the bulwark of this, thank you. We really appreciate it.
and thanks to Richard Rifkin as well, one of our helpers. Thank you.
No, I really want to thank all of the panelists and our two moderators. And I hope this is going to be the first of many, many convocations like this one. And I hope you'll spread the word and come back again. And in the meantime, please come join us for a little repast downstairs in the East Foyer.
Great.
Thank you. Thank you, Susan.
Thank you.